I'm Karen Gilmer. I am an alienated and erased mother. I am saying erased because at this current moment I have got no idea where my child is. This nightmare started in 2017 when she was removed out of her country of habitual residence by her other parents. Prior to this happening, I alerted the SAPS as well as the consulate of the country of who I assumed the child would be going to, because the other parent works for an international bus and truck company. She alerted me in June of 2017 that she is thinking about immigrating. At that point I said to her, but you cannot just do that on your own, as there is a High Court order in place, which at that time was also not being adhered to by her. I am saying her because the child born from this relationship was of a same-sex relationship, which was entered into a marriage in December of 2006, and the child was conceived by artificial insemination. I am, however, the biological mother of the child. So because I assumed that my child, our child, in fact, it's not mine, our child was going to be taken to Belgium, I contacted the Belgian consulate and they indicated to me that there has been an application made for visas, long stay visas. I sent them a copy of the High Court order. However, in September of 2017, she was removed out of South Africa. I then got into contact with the family advocate, the very same family advocate that wrote the report, which landed me with a High Court order saying that there must be reconciliation therapy between my child and myself, as well as that I would have interfaced supervised visits by the other parent, as well as they took away my guardianship. On the day that this High Court order was made, I was not present in court. I was not informed of the court date. I simply received the court order. The situation currently stands like this. I eventually managed to make contact with the Chief Family Advocate and Regulating Authority to the Hague Convention of South Africa in June of 2018. I am now on my third draft of documentation that the Central Authority in Belgium have asked for after they formally opened up the case file. I'm going to read what the Belgian authority requested. The applicant should confirm in writing what kind of access arrangements are sought, contact via internet and or in person, school, medical information. She can be as specific as she wishes. Example, where should the access take place? Who will drop off or collect the minor? And who will be in charge of transport costs? As I said, I am now on my third draft. The Chief Family Advocate keeps returning my affidavit, as well as my request for what contact I seek, as on every occasion I have been requested to move every section relevant to what is going on here, which pertains to sections out of the Children's Act, to remove those sections from both the documents. In February, I received an email from the Chief Family Advocate stating that it seems like the email communication is not good enough for me to understand what it is that they request from me, and that they now want to meet in person. I suffer from spinal muscular atrophy, and I make use of an electric wheelchair. So travel, number one, is the issue. Number two, my health has been deteriorating due to stress and missing my daughter. I have asked on 2 occasions whether it would be possible for the meeting to take place at my residence, and I'm now not being answered at all. This is not a unique problem in South Africa. Mainly fathers suffer from alienated from their children. Mainly fathers suffer the consequences of a system which is not conducive to 50-50 parenting. I am making a plea that this problem gets addressed by the Minister of Justice as soon as possible. We need our children, and our children need. Day marks 1,261 days and 180 weeks that our child has not seen her biological mother or her biological family in South Africa. This is unacceptable. I have been making every possible attempt just to establish contact with my daughter. I need to speak to my child.